Thank you for joining us on this episode of Legal Angle with Emmanuel the Law. Hello, Ali. Today we'll be talking about how to protect your home from foreclosure and other consumer protection issues. My guest today is Troy Doucet, a former mortgage broker who became a lawyer who sues mortgage companies. And he is the man to call if you want to go against the bank, against mortgage company, or against lenders who are taking advantage of you. So welcome to the show, Troy.
Well, thanks for having me. I appreciate it. Pleasure to be here.
Hey, can you introduce yourself to our audience so that they know who you really are? I know you have a lot of horns to blow or to toot, so I'll let you do it.
A lot of pain and suffering, a lot of lessons learned in my life, if you will. My name is Troy Doucet. I represent people going through foreclosure. I do a lot of business-related work for folks that are having troubles with their businesses. The majority of my work has been in the mortgage business and the foreclosure defense area. I tell people I sue banks, mortgage companies, and debt collectors for a living. I have a firm. We're located here in Dublin, Columbus area. We do also have a Cleveland branch, and we focus on cases throughout the state. Most of the time, my clients are facing foreclosure or at risk of foreclosure and want to save their home without having to file bankruptcy. So we step in, we litigate cases out, and do what we can to help people stay in their home. I was in the mortgage business for a few years before I got forced out, shall I say, and then we decided to go to law school. Went to Capital here in town, Capital Law School. Enjoyed it, did well. Graduated in 2010 as a second profession, so I'm 10 years in this next month or months from now. And went to OSU, for Ohio State University, as an undergraduate. And when we can these days to help people out.
Wow. So how did you get into foreclosure defense?
Well, with my background in the mortgage business, I understood where the bodies were buried. I understood the way that the mortgage industry worked. My business failed. I had a mortgage business before I became a lawyer. It failed. I ended up in foreclosure and bankruptcy myself, and learned a lot from that experience. Took those lessons and applied them in school, and then realized when I got out of school that this was a great match for my own understanding and knowledge. I did, during law school, going through foreclosure myself and defending it pro se and doing what I could. I learned a lot of valuable lessons, and I also compiled the defenses and the work that I was doing into a book format. Actually, it was more of a brochure format at first for other lawyers to help them understand the area. But then I began compiling a lot of these defenses, how they worked, how they operated, and compiled them all into a book. It's 23 Legal Defenses to Foreclosure. Those little booklets ended up being about 440 pages in outlining how to defend foreclosure. I published that book in 2008. I graduated law school in 2010, so when I came out, I had somewhat of a not only an understanding, not only helping other lawyers, but also having experienced it, that it played very well into me deciding to focus on this as a practice area. I have to tell you, too, there were not a lot of lawyers that, especially in Ohio, defended foreclosure 10 years ago. People didn't view it as a valid thing. Foreclosure defense, there's no such thing. And we had to come in and really work hard to change the opinions of lawyers in the area, as well as the judiciary, and some of the judges who were very frustrated that I was raising these claims for my clients. Ultimately, it took a few years, took us 5-6 years to start getting some decent decisions out, and it was very frustrating during that early time period. But thankfully, we've done some good work, I think, and we've got the law a little bit better for consumers today, and their cases are taken more seriously because of the work that we've done, just hitting our head up against the wall, if you will, or the break through it. So that's what it's been all about.
Wow. So you came into the practice during the time that a lot of people were going through foreclosure, because from your timeline, it seems you started during the bubble,
Yeah.
the mortgage bubble of is it 2009, 2000?
Mm-hmm.
Yes. Wow. And
Yeah.
yeah, go ahead.
No, it was going full throttle when we when I became a lawyer. It was 2010. Really, the recession started 2008, 2009. They started. I did a bunch of work for legal aid while I was still in law school. I had about 250, 300 hours worth of time with legal aid in their foreclosure defense section, sort of working and developing a skill set there and practicing my, become my trade. But when I got out, you're absolutely right. There were a ton of foreclosures. Um, there's a whole, I blame the banking industry for that and the way that, especially the mortgage servicers, the way their profit models were set up. A lot of people who went through foreclosure that did not have to go through foreclosure, but because the system was not very efficient, a lot of people lost their homes they shouldn't have. It created sort of a cascading effect throughout the whole market that once one person started, once one person on the block loses their home or two or three, then real estate property values go down and people who might have been on the verge or might have been considering it ended up sort of in the foreclosure too. There's been statistics that show how people can get pushed into it if enough of their market, their neighborhood is in it itself. So we're not really any stop gates. We were in there early on saying, these banks need to be doing something to help people out. They need to be, doing loan modifications. We have situations where clients are willing to pay back every penny that they owe. They're willing to make up the interest, but you just can't do it as a lump sum. We were asking, we'll stick it at the back of the loan, rewrite the loan, do a loan mod. And we weren't getting anywhere. The infrastructure wasn't there with these servicers back then. They didn't want to spend the money either on it. So you just had this big push to clear out all the foreclosures. People sometimes think that it was because people couldn't afford their loans, and that's why they go into foreclosure. But reality is it's much more complex than that. You've got, servicers and all kinds of stuff. I can tell you more about that if you want, but you're cool.
Oh, that's interesting because what you did was that you use your own personal experience and you translate that into fighting for others. And there's no better or bigger motivation than that.
Yeah, I was bullied as a kid too, so I don't like bullies very much at all. So I have worked very hard to build a reputation of um, uh, of not letting go, biting in, sinking my teeth into the litigation and going all the way to the end. We took more appeals than I don't know anybody else that does this particular line in Ohio. I appeal everything because when we're right, we go up, we go the distance. And I want the other side to understand that too. It's helpful for the clients, for my clients, to know we're going to work hard. But it's also helpful for the banks to understand that we're going to cause them to, spend a lot of money on their own lawyers if they really want to fight us all out on this. Because when we bring something, we understand what is, legally sound, and we bring those things, and chips fall where they may.
So, in a situation where a homeowner is already behind on their mortgage, what advice do you have for them to avoid foreclosure?
That's a very good question. Right now, as of September 2020, there is the Federal CARES Act. The federal government passed a law in March that enabled everybody to defer their payments that needs a deferral up until probably next March 2021. So until that time period, it's almost an automatic process. If you can't make your mortgage payments or even miss one, that those will be deferred out till March. Um, if you have the ability to make your payments, I would recommend you pay it. I don't recommend you rely on the mortgage servicers getting this right in March 2021, because as we were just talking about, this is part of the problem 10 years ago, is that everybody needed help at the same time and the infrastructure wasn't in place. The servicers couldn't handle it. I don't know what they're going to do in 6 months from today, whether or not they'll just roll everybody's loan into a loan modification and let everybody be current again as of March. But if somebody's having trouble paying their mortgage right now, I would say do what you can to make that payment. If not, know that that's out there, but you probably want to reach out to your mortgage servicer, let them know that you need help, let them know you need some kind of loan modification or resolution, and see what they can do. If your situation is not over yet, if you're still have a decrease in income, lost your job, you don't have one job yet, and your servicer is willing to roll you out until March of 2021, if they're not requiring you to do loan mod, I actually would recommend that you not apply for loan modification, because the federal law that governs all that limits a lot of these to, in a lot of situations, to 1 year. You can only get one loan mod a year. So if you're not really in a situation where you can make your payments or reduce payment today, don't use up that one shot right now. Wait till maybe January, February, and then apply for it. You still want to call your servicer, let them know you're going through trouble, see if they can have some kind of deferment or push payments out. But that's what I would recommend. If you actually, if the money piece of it is the issue, then you might be able to. There's some programs that are still available, some social services related programs. I know legal aid deals with that quite a bit. I don't see very many foreclosures being filed right now. If you're in the situation where they're actually filing a foreclosure, you probably want to talk to a lawyer immediately. As much as I did my case pro se, by myself a few years ago, I don't really recommend it at this point. It's technical to maneuver around.
Okay. If you get a loan deferment right now, does that mean they're also deferring the interest rate or they're only deferring the principal? So do you have a compound interest rate accumulating at the end of the deferment?
That's a very good question. The federal law that just passed does not allow them to add on extra fees, costs, or expenses as part of the CARES Act. So right now, you don't really have the compounding interest related problem. It's just going to be one lump sum, those payments, and then those payments would get tacked on the end. And actually, not the full payment wouldn't get tacked on the end because, as you brought up, part of that is principal balance. So just the interest that accrues, you didn't pay over a month, the period that you didn't would be tacked on the end. But yeah, you should not have fees or costs or expenses that are added on. That'll be very interesting to see. If come March, after all this is over, if the mortgage servicers try to add those on, I'd be happy to talk to people about that because they shouldn't be doing it.
Yeah, we also have situations where people are not able to pay their property taxes in this kind of situation where everyone is going through some kind of financial stress. Is there anything out there, that in the CARES Act that gives them relief against paying property taxes?
No, unfortunately not. In fact, property taxes and homeowners association dues are the two types of foreclosures that we are seeing still, or we're hearing a little bit more about. CARES Act is actually specifically tailored towards government guaranteed loans, Fannie Mae, Freddie Mac, FHA, VA, USDA loan. They represent about 70% of all the residential loans on the market right now that applies to. CARES does not apply to the 30% or so that are not guaranteed, but most of the servicers are still allowing that delay. When it comes to taxes, though, or your homeowners association, there's not a lot that the law does. Usually, if you have, when it comes to taxes, if you have a mortgage and you're paying on your mortgage, the major servicers will usually forward taxes so your taxes aren't in default. So if you actually have a mortgage loan and you're also behind on taxes, probably, if you look closely at it, you're probably actually not behind. Your mortgage or servicing companies probably fronting those. Homeowners association dues are another thing. However, some associations are easy to deal with, others are not. It's very frustrating for the people that call me with HOA dues that are behind, that they end up in foreclosure, because the way Ohio law works right now is that you as a homeowner have to pay every penny of that money plus all the attorney's fees and costs. I've got a suspicion that some of these big law firms file these HOA foreclosures more interested in the multi-$1,000 payment they're going to get than they are necessarily over the $500 or $1,000 homeowners dues that are past due. I see that. I see the dues are $1,000 and client's behind, the foreclosure's filed, and then you got an extra 4,500 that's added onto that, and lawyer and court costs and whatnot. So if you're behind, I would really try to remain current with those, because if you do up in a foreclosure by one of those two entities, there's not a lot of defenses, and that's hard for me to say as a foreclosure defense lawyer, but there just simply aren't. And if you fight the HOA, you're still going to be paying their fees at the end, so it's diminishing return for a lot of people. Taxes, if you're behind on taxes and you don't own a loan, don't go to a bank, you don't have a mortgage, you just have to pay your taxes. Sometimes people inherit property, not able to pay the taxes. Sometimes they might have two parcels and they're not aware that they had another parcel and they don't pay it. That happens. The way that Ohio law works is you're at least 2 years out from losing your property for non-payment of taxes. And most treasurer's offices will do a deal with you to get back on track, even if you're behind. Even if a lien company buys the tax debt, usually a treasurer's office will be willing to work with you. So if you have a tax debt, I'd recommend to call the treasurer's office. But it is tough to defend if you're actually in foreclosure, and it's a very large sum.
Thank you. Is there a reason that HOA claims or liens sometimes supersedes even the mortgage company liens, that HOA can foreclose on the property even though you're paying the main mortgage?
Well, it's the way the Ohio law is written that the HOA is first. It's sort of an interesting situation because sometimes we see them not. But for the most part, they'll step ahead because the condo associate or the homeowners association paperwork is filed with the county's recorder's office when the development is being established, when the association is being established. So because it's on record and it's first in time, a mortgage company coming in later on is going to be, their mortgage would be making, they'd be recording that after the HOA. That's why HOA will generally take first. And they can foreclose on any dollar figure. Even for some lenders that are in secondary position or lien holders, even if they're totally underwater, let's say your home's worth $100,000, mortgage is $95,000, and then you've got liens for $10,000. You're underwater. That $10,000 second holder is not going to get anything if it goes to foreclosure. They can still foreclose. It's their right to foreclose and force everybody to sell the property. You don't see that too much because people don't like throwing money away. But if you get somebody who's just really spiteful, or you know what they say about people and personalities.
Yeah.
So.
Do you, as a homeowner, have the right to say, you know what, I don't want to join this association. I don't want to participate. I just want to own my home, and I don't want to deal with you guys?
Yeah, good question. No, the answer is no. No. If you're already in now, if the association is not set up yet, then and somebody wants to set it up, then you have a vote on whether to set it up. And I don't know what the rules are on that. I don't know if you need to 100% buy-in from the community or a high percentage. But if your property is already in an association, you can't get out. No, you can't take your property out.
Isn't that itself against antitrust laws?
That's I don't think so. No, I think it's a totally different or a different areas of laws. I've never thought about it in those terms. I have to give that a little bit of thought. But no, I don't think you're going to find a judge that would overturn all the homeowner associations, because you have different types, right? You have condo developments that properties are all next to each other and they're all attached. You have other associations like the one that I live in. It's a single family residence subdivision. We have a formal homeowner association. My dues, I think, are $50 a year, but it is in that. Yeah, I don't think so, because it's really you're putting everything together as a collective in order to for the collective benefit of everybody, versus Yeah, no, I don't think so. I don't think you're going to get a judge to do it. I'd have to look at the laws, but all right.
Do we have the same protection for residential buildings as for commercial buildings when it comes to foreclosure?
You have more, much, much more. So, from my perspective, as a consumer lawyer, as a foreclosure defense lawyer, I can do all kinds of things on the homeowner side of the aisle that I can commercial. Commercial foreclosures, we do have the ability to attack them um, and defend against them, but it's a little bit more challenging. The consumer protection laws do not apply to commercial transaction. So the Truth in Lending Act, Real Estate Settlements Procedures Act, for the most part, Ohio's statutory schemes won't apply to commercial transaction. Also, when you have a commercial transaction, a lot of times the bank can just go in and immediately obtain a judgment through a cognovit versus having to go through the full process on the consumer side, on the residential side. Um, so definitely different laws. I do have a case right now, commercial, big, massive commercial loan um, that we're litigating out, and we're about to get into some litigation over some other interesting concepts, things like the Equal Credit Opportunity Act, possible discrimination-related claims in lending. There's data out there that's maintained by the federal government, might give us a little bit of headway into that kind of situation. But yeah, if you definitely want counsel if you have a commercial transaction, definitely don't. You can't do it yourself if you have a corporation anyway. You have to have a lawyer. So.
Thank you. And talking about litigation, you're currently involved in a litigation against, in regards to student loan. Is it against the federal government or against the mortgage company?
Yeah. All right, well, the class actions against Betsy DeVos and the Department of Education, the Federal Department of Education, say for teach grants. They were representing teachers who agreed to go into targeted districts, special needs districts, and teach for a period of time in exchange for getting grants in school. So they were provided grants, and then if they worked in these districts for a period of time, then those grants would be forgiven. Well, what their servicer was doing, and the Department of Education servicer on these loans, where they were forcing them to fill out these forms, but saying that they either filled them out a little late, they checked the wrong box, they did something else, they're de minimis, something nominal, something not important, failed to do that. And because they failed to do that form correctly, these grants were being flipped into loans. And these teachers were being asked to repay the full dollar figures, $4,000 a year, effectively. And we said this is a breach of contract, amongst other claims. We actually filed a racketeering action against the servicer as well, and to litigate that out. That case, that class that we filed, right after we filed it, or shortly after, there's a few other lawsuits that got filed nationally against these servicers in the Department of Education, and they all got consolidated into we call it multi-district litigation, MDL, out of Philadelphia. And I am on that committee, although slow-moving lawsuit at this point in time. Hopefully, we're just in the pleading stage. We hope to represent the teachers that experience this.
Okay. And that's a national lawsuit.
Yes, it's national.
Yeah. Do you also represent like students against fighting against their lender and student loans?
No, we haven't got into that. There is a firm here in town that does do that, student loan debt. We have not got into that as of yet. We also don't file bankruptcy.
Yes, I was going to ask you about that.
Yeah, we don't do any bankruptcy. Very rarely. Actually, every so often I'll go into bankruptcy court. We're trying to get a couple of class actions certified through the bankruptcy court system for violations of the Chapter 13 stays. These banks, the mortgage companies, were charging people money that they weren't allowed to under the law through the bankruptcy system. We filed a couple of class actions, tried to get them class actions. Both of them ended up getting resolved, so they didn't turn into a class. We will get into bankruptcy court for that purpose, to enforce people's rights, to actually discharge debt. We don't do that. Similarly, student loan debt, we haven't got into that. I know there is somebody in town that does it. Suppose that you could apply similar rules. You can. What we do on the residential side, as a practical matter, if the student loan debt is $10,000 or $15,000, it usually doesn't make a whole lot of sense for us to throw $30,000 worth of litigation time into the case. That's really the big hangup. If somebody had $100,000, $200,000 in student loans, and they wanted to litigate out those kind of issues and see what was, what's possible or not. Is write down possible? Do they have the paperwork? Does the loan actually exist? Have they followed, across their T's and dotted their I's? We would entertain that. I mean, I would do that because this is consistent with what we do. But usually it's a practical financial reason why we don't usually get into those.
Thank you. And your goal is always to help clients fight against creditors without having to file for bankruptcy. How do you accomplish that?
We countersue usually. That's a good question. This is what we do some better defense, and it can be very small dollar figures, $1,000, $2,000, and we'll take those cases on. The difference with those cases and student loans is that student loans don't usually fall under a federal law, the Fair Debt Collection Practices Act, allowing us to recover attorney's fees from the other side. Debt collectors, however, are subject to the act, and they almost always screw up their paperwork. So we will we'll defend people who are being sued on small dollar figure debts, $1,000, $2,000, $5,000, because these debt collectors never have their paperwork in order. If they file these actions without their paperwork, without being able to prove their case, then they've taken false action effectively, and that triggers liability. Both for them, the debt collector, but also usually the law firm that filed the lawsuit. So we do go after law firms from time to time, not all the time, but we will from time to time. If they're doing something egregious and they're subject to the law, those are defendable because they never have their paperwork. And as I said, we can recover fees from the other side. So it makes it economical for us to do it, and it helps out clients. Our standard settlement on that side of things is for our client debt to be wiped out. Client get $500, maybe $1,000, depending on the case, plus all of our attorney's fees paid. So debt wiped out, the client, our debt, our bill paid, and sometimes we can even remove the debt from their credit bureau completely, or at least that debt collector. We negotiate to have it removed.
Yeah. How do you do your fee structure? Do you represent clients? Well, I wouldn't call it pro bono. Do you have the client front the fees, or do you wait until you get your attorney's fees paid by the other side?
It depends on the case. Our foreclosure cases are where our clients are not making their mortgage payment. They're going to be paying us something every month. It's never the higher than whatever they'd be paying, or rarely higher than whatever they're paying. They're going to be paying us something each month to litigate the case out. We have the ability to do this on a flat fee basis, where the dollar figure every month is a flat dollar figure, no matter how much work is done. Those are all inclusive. We do depositions. I do absolutely do depositions in those, robust discovery, litigation. That makes it affordable. We also have a fee shifting provision, FDCPA claims that I just mentioned to you. The client won't pay us anything. If we recover from the other side pays us. If we don't recover, the client doesn't pay us anything. Sometimes we'll do monthly minimum payments where we bill on an hourly basis, but the client doesn't pay the full bill each month. Instead, they pay a monthly minimum towards it. Sometimes those are consumer-related claims, claims that that have some fee shifting that might be possible, but we want the client to have some skin in the game. They might pay us a few $100s a month towards their case. And then if we win, we recover the balance. But if we lose, then we wipe out whatever we are owed. So we don't usually take on cases that we take like a third percentage, like PI lawyer, personal injury lawyers do. For us, it's usually just an hour, and almost always an hourly calculation.
Okay. So if you're able to get the fees back, do you give the clients a refund?
Exactly. Yeah. If the client's paid us their monthly minimums and we recover 100% of our fees, that's exactly what we do. We refund back to the client what they paid us. But yeah, so it's whole. In fact, sometimes it's very beneficial for our clients who have been paying us. Sometimes we can get it done on foreclosure case. That's even better for them. And usually the way we structure that is is that restructure it so it's a refund of our fees, and that also avoids some tax implications for our clients. But we don't tax advice, but we that's exactly what we do, is refund it back. Mhm.
Okay. Now, let's talk about consumer protection when it comes to retail services. What happens in a situation where you go to a store or to buy something from a store, let's assume it's a store, and then the product itself is defective and they wouldn't accept a return? What remedy do you have as a buyer?
Good question. Also, the Ohio law, every state has a consumer protection statute. In Ohio, it's called the Ohio Consumer Sales Practices Act. It's revised code section 1345.01. If somebody wants to Google that as they're watching this, or push rewind and go back to it. It's the Ohio law governs transactions between individual people and businesses. It includes retail businesses, it includes any kind of business. Whether you're going to a store or even service providers that come out to your home, they paint your home, they do, plumbers do repair work, um, home sales solicitation. It even covers things like gym membership and dating applications, um, all kinds of different things. Anything where you're an individual person doing something, buying something for primarily personal, household, or family purposes, then this law will protect you. And essentially, the CSPA is a smell test law. If it smells bad, if it looks like a bad transaction, it probably violates this particular code. And if it violates it, then you have a bunch of remedies that are available. You get to choose. You can unwind the transaction, rescind the transaction, return the goods, or get damages depending on how bad things are or what you decide. A lot of times when people go to, I get a lot of calls on auto mechanics, for example. We stopped taking we stopped taking those cases a while ago because it can be challenging to collect against a mechanic. I always email out a standard email that tells people about the CSBA. You can go to small claims court. Mechanic messed up, $500 claim. You can sue them for $500. You might be able to sue them for three times that, $1,500, plus up to $5,000 in non-economic damages. But you can take a $500 case and turns into $6,000 and file that in small claims court to remedy whatever problem you had. The fascinating area of law. I just are real thrilled about it, or we'd be doing more of it. Um, and also one of the challenges we have is the collectability. If you sue use car lot or a auto mechanic, you've got to be able to collect as well, and that's something we've had problems with in the past. That
Thank you.
answer your question?
Yes. Now let's talk about used car. What protections do you have as a buyer when you buy a used car? 2 or 3 days after you drove out of the lot, the car broke down,
You have
and the seller will not take it back.
no rights. For the most part, no rights. There's if it's a used car and it's an as-is transaction, you're stuck. It could break apart as you're driving it right off the lot. If it's after the transaction, you're stuck with it. It's one of the most important reasons why you get an inspection of the car from a mechanic, spend $100, go get a mechanic to review it, to inspect it and make sure that it's a decent car. You have no right. Even sometimes you can buy extended warranty or extended warranty for used cars. My experience with those is that they're almost universally worthless. You spend $1,600 or $2,000 for this warranty that's baked into the car, and then something happens and it's effectively useless. Everyone that we have experienced, I want to say every single one, the client has not been able to get the repair made. Very rare. So I don't recommend getting those. I just recommend you spend the money to talk to a mechanic. If you go to a good qualified mechanic also and they miss something, you can actually have a claim against the mechanic for missing it. You probably don't have it against the car dealership. Even if the car dealership lies to you straight out and it's fraudulent inducement or fraud, it can still be very, very difficult to recover. The Supreme Court of Ohio came out with a decision about 10 years ago or so that little old lady was taken advantage of and told a bunch of lies. She bought the car, and in the contract it said, the integration clause, it said, anything we told you prior to you signing this doesn't count. The Supreme Court said, you signed it, so we're good enough at their fraud to convince you to do it, but you don't have a CSBA claim for it. It was very frustrating for that woman, unfortunately, as well as consumers after. So yeah, not all that you can do. There's no 3-day right to cancel, even with new cars. The thing that you have with new cars is a lemon law. So that is if you have a brand new car you buy, and within the first 18,000 miles or 12 months, if the car has major issues, or if it has minor issue, a bunch of minor issues, then it can be considered a lemon, and you can return the car and get all your money back. You don't have to file a lawsuit within that first year, but those problems have to accrue within the first year. I just talked to a guy yesterday, actually called me up. He had a Range Rover. It even applies to really nice cars. Brand new Range Rover he bought last year, 10 times in the shop, over 30 days within the first year. That pretty much triggers Ohio's lemon law, and we're going to help him out on that case. But that's a new case, new cars. There's no 3-day right to cancel car transactions. Or 3 days and other transactions, I'll tell you what they are if you want to know, but not for cars.
Yes. I have a question that just pops up. What if you sign up for a product and they had you sign paperwork to sign up for the product, and then find out that they signed you up for a loan for some product? Do you have any right? You didn't want to do a loan. You just thought you signed up for a service. I guess that's a contract issue. Yes.
Well, so I'll talk in generalities without a specific legal issue for a particular person, because I can't do that in this kind of form. But for general matter, what I would look at for this is a couple of things. First, I would look at what was the transaction, where did it occur, what was the product. So if you had some idea what the product is, this would help sort of analyze the situation. If you have and then also where the sale happened. So if a sale happens in your home, somebody comes to your home, there's an area of the CSBA that will give you extra protections. That's the HSSA, Home Sale Solicitation Act. And that's where you do get 3-day right to cancel, and the form has to be very technically filled out. So if the forms aren't filled out, if the disclosures given to the consumer are not correct, the consumer can cancel at any point in time until those proper disclosures are provided. And if they need to go to court, we can sue and get attorney's fees back for that. So those are transactions where somebody comes to your home, usually plumbers, electricians. They'll apply. So you buy a knife set from somebody, you buy steaks out of the back of a truck. Those will apply. We have a case right now where a woman bought a wrinkle cream at the Ohio Expo Center. This supplier there is subject to this HSSA, and he didn't provide any of the required disclosures, so we're able to recover on that front for her. In that kind of situation, I'd look at where it was. If it was a service like a gym membership, or we have done gym membership cancellations, that kind of thing, same kind of form. If it's a regular store that signs you up for something that you don't want, you do have, as you mentioned, a little bit of a contract issue. Is there a fraudulent inducement? Did they tell you one thing and the contract says something else? That is one way of looking at that. Another way of attacking it is the CSBA, is the smell test. I only wanted to buy this. I didn't want a loan on this. And you sold me something that you told me were different. Therefore, because you lied about it, it doesn't pass a smell test, and you violated the CSBA. And maybe you might have a small claims court lawsuit to get your money back, whatever you paid, or if you're going to cancel the contract, that's a little extra step. But there's a additional analysis, and then I'd also want to actually look at that contract. What does it say? And what rights are reserved? That kind of thing.
Yeah, I think, you're right. I think it's going to depend on the contract. Did they give you time to review it? Did you actually sign it? Did you have enough time to review it? Just because what a lot of people don't understand is that just because you didn't read a contract doesn't mean that you can be bound by it.
Right.
If you sign contract just as you accept what some of those terms and conditions online. You just click yes just to go ahead. You can still be bound by those contracts.
Yeah, it's yeah, you're right. I mean, it's there's a lot of complexity to it. I do say sometimes, and somebody said this a while back to me before I was a lawyer. You can have a contract to kill somebody that doesn't make it legal or
Yes.
enforceable. So you can have an illegal contract that you don't have to be bound to if it's actually illegal.
There you go.
And if you're, if there are issues, if it's your grandmother and she has dementia, and they sell her into this contract that is outrageously priced, you can have an unconscionability related argument also to get out of a contract, even if it was fine. So yeah, go talk to a lawyer. A lawyer should be able to help.
Yeah. Thank you. Yeah, talking about something being egregious. Earlier this week, I saw a cash advance contract loan being offered for an APR of 242%. This person wants to take a cash advance against recovery from a personal injury case. Is that lawful?
Law has changed quite a bit over the last year or so. Actually, the last maybe 6 or 7 years. I am not up as I could be on the on cash advance loan. There was a period of time where they required some degree of collateral for these cars to get out from underneath the statute the way that it was written. And the Supreme Court struck down the statute. Then there was a modification of the statute last year, and I don't know when that goes into effect, what can be charged or what cannot be as far as those rates are concerned. There is somebody in town who I could refer people over to if they have one of those situations. Her name is Emily White. Emily White is her name. She does some of that. She does the student loan work, at least has in the past as well.
Thank you. If you're listening to this or if you're watching this, one thing you take note is that buying extended warranties is useless. Is that correct?
Used car warranty, even the Consumer Reports recommends not doing that. Yeah,
Not to do
it's
it.
not recommended. The value for those is is generally not worth it. Yeah,
Excellent.
don't do it.
In a
Get the inspection
situation,
done instead.
okay. What happens in a situation where you have a building contractor file a mechanic's lien against your home? And the main reason they did that was because maybe you hired them to do work on your property. They didn't do a good job or they didn't complete it. So you hold back on paying them, but they ended up filing a lien against your home. How do you get rid of that without having to pay them for the work they didn't do?
Well, I have yet to see a building contractor comply with the Home Sale Solicitation Act. So the HSSA is a subsection of Ohio law under the CSBA that requires anybody coming out to your house to do work that under most circumstances has to provide you required disclosures. If they fail to give those required disclosures to you, you have many rights. One of them is the right to rescind the transaction, effectively not pay. Not only is it not paying, but you can actually recover your costs and attorney's fees from them for doing something like that. So interestingly, I had my house painted a couple weeks ago, and I painted the trim. They were painting the trim around the windows, not the main stucco or anything, but we wanted the trim all painted. And they came out and painted all day, and great job on it. I thought they were terrific, except for the fact that around each window they did not paint one area of the trim, for where the vinyl window attaches. There's this area, this section of aluminum trim from old windows that was still there. Well, they didn't paint any of that. And I came home, so I've got this like all of my windows outlined in a different color than the trim. I've got the windows are one color, the trim on the outside, and then they left all this. So I've got this rectangle. And I said to them, guys, the contract, you agreed to paint the trim all white. Why do I have brown square rectangles around all my windows? And started cussing at me and swearing at me, and I'm like, look, I say you got to stay professional about all this, but at the same time, I'm saying to them, you got to finish this. He's like, we want more money to do that. I said, but I'm not paying you more money to do that. You already agreed to do that. And the contract doesn't comply with the HSSA. I'd love to pay them. In fact, for their work, I will pay them something for their work, and I think that's the right thing to do. But it's not going to be the full contract price because they didn't finish. I'm going to go get somebody else to do it. I got to do it partly myself. But the way that if they were to file a lien or something, I have the ability to use that HSSA in order to wipe it out if I need to.
Is that something you can do for someone out there who is in that situation? As an attorney, can you
Sure.
represent them?
Yeah, absolutely. It's something, though, that as much as I have the ability to do it, again, there's numbers involved. There's the economics. Just because you have a lawsuit, if you got some guy coming up and doing, siding work, works out of his van, he has tools, and that's those only assets. He doesn't have anything to pay your judgment. If you get it against him, then we're gonna think long and hard as a law firm about taking it on a contingent basis. The consumer would have the ability to not only wipe it out, but do a small claims lawsuit in order to recover up to $6,000 under the HSSA and DSBA, and then they can collect on whatever assets they're able to.
Yeah, so what can you do as a consumer if you see something on your credit report, which you're obviously still disputing, or you see it on your report and it has affected your credit rating? What remedies do you have?
Yeah, we do FCRA related work as well. There's all these acronyms, all these consumer statutes.
Which is
There's
FCRA?
FCRA is the Fair Credit Reporting Act, and it requires that the credit reporting agencies, TransUnion, Equifax, Experian, accurately report your credit. And if you have something on your credit that is inaccurate, you have the right to write them a letter saying this is inaccurate. And then when they receive that, they have 30 days to either contact that creditor, contact them and verify it's accurate, or they have to remove it. The CRA has to remove it from your credit bureau. So there could be situations where you've got something, it's not correct, and the credit reporting agencies are not removing it. What I recommend people do is write that letter, follow the letter up, include proof that it's inaccurate. Include, if it's an identity theft situation, include a copy of your police report and demand that they remove it or correct it. If the credit reporting agencies don't correct it after you do that, you do have, and it's inaccurate, you do have an action, you have a lawsuit under the Fair Credit Reporting Act. Those we take on also because they also have mandatory fee shifting. The other side has to pay our fees if we win. Those cases generally settle out very quickly, and usually the client gets their correction as well as maybe $1,000 or so, and we get our fees paid out on those. Consumers do have the ability. FCRA does not necessarily require the underlying creditor, the underlying company, the loan company, the bank, take correction directly. Rather, that your remedy is really against the CRA directly under the FCRA, credit reporting agency. Yeah.
So do you get money damages, or do you just get correction?
Correction of money damages. Yeah. It's not a whole lot. You're not going to retire on this money. I mean, you're talking $200, maybe $1,000. You're entitled to it. So we do pursue that. We did more of that a few years ago than we do these days. These days we focus a lot on foreclosure defense as our main area of practice. But yeah, we do take those on.
Yeah, as a result of COVID, there's been a lot of shutdown. Canceled airlines, canceled hotels. Let's assume that you've made reservation before the shutdown, and you're not able to make the trip. You're not able to fly, and now you're having problems getting a refund from the airline or the hotel. What remedy do you have? What can you do?
That's a little bit more complicated. There are some, I understand, actually, just reading the paper this past week, there's been a class action filed against all the major airlines for not refunding people's money, giving them vouchers versus refunds. Those would be situations that refund would probably be appropriate versus a voucher, because you have agreed to pay the dollars and they have agreed to provide you the flight. If they're not able to provide meet their end of the contract, they're violating the contract. Are there terms, conditions within the contract that you end up signing one way or another, buried in these things that say you get a voucher? That's what the litigation is going to be about. Generally, if they are unable to provide, if they've closed down the hotel or they've closed down their systems, and you can't get the service that you paid for, you should generally be afforded a refund. If it's a business and you're doing it for personal, family, or household reasons, you're going on a trip, then the CSBA would also apply to those situations. So you might not just have a contract claim, breach of contract, you file small claims. You might be able to add on a CSBA claim and get additional damages beyond what you paid and they didn't refund to you. But those are more complicated also because if you're dealing with out of state, if somebody, you're going to Florida hotel, does Florida law apply? Does Ohio? Does Expedia's choice forum apply? They are a little bit more complicated. So, but there are class actions.
Yeah, can government agencies be held liable for violating consumer protection laws?
That's a good question. I'm going to go with no on that one. Maybe phone a friend if I had the ability to. No, I would say no. The CSBA, I think, has a specific carve out for governments. So I think you have to do an analysis on each individual statute. But overall, I can't think of one off the top of my head that would apply to a government agency. Yeah.
So tell us about your book, The 23 Legal Defense to Foreclosure to Beat the Bank.
It's a book designed to help people fight foreclosure. You can go on. You can. It's Amazon. It's available on Amazon. We're working on a second edition of it. It's 10 years old, 12 years old now. The laws are still pretty good in there. The defenses are still good. It's designed to help people understand not only the defenses to foreclosure, but also written in a way that people can follow. Somebody can do it themselves, pro se, if they wanted to. Sort of, easily explains what is, what is a claim, what's a defense, how discovery works. I even modeled discovery for these kind of claims. A lot of lawyers have purchased it actually for their practices and do this in different states. It's been helpful. It's been I think, a good addition to the law library. If nothing else, if you're looking for something to put you to sleep at night, great read, help you fall asleep.
Okay. Tell us about the Art of War for Lawyers.
Art of War for Lawyers. I took Sun Tzu's Art of War, a 2,300-year-old manual on art of warfare, and I analogized it to litigation. So each chapter on the left side is Sun Tzu's manual, and then on the right side of the book is my analogy to lawyers and litigation. I think it's just a fascinating book. So The Art of War is just a fascinating book, and I thought it'd be neat to sort of apply it every day. In fact, I took notes in my copies of The Art of War for a while, and I was like, yeah, might as well just format this into a book. That's what I did. It's out there too.
Okay. Yeah, for people out there who, before the CARES Act was passed, were going through foreclosure, but maybe their cases were stayed because of COVID. So, do they also benefit from the CARES Act, or the foreclosure can continue as soon as the court reopens?
So they are protected. So the Ohio courts did stop stayed all foreclosures, stayed all cases really for a period of time. That's been lifted. Some individual courts are allowing cases to proceed, even if a servicer wants to proceed in foreclosure, and if your loan falls under the CARES Act, they're not allowed to. In fact, if they try to do that, I'd want to talk to them because you probably have a claim, again, under the FDCPA, as well as a really good defense to the underlying action because they're not allowed to do it specifically. So somebody's facing foreclosure, I'd want to take a look at it. Yeah, it shouldn't be until March of next year, probably.
Thank you. Apart from litigating and fighting bullies, how do you stay in shape? It's,
I do a lot of gardening. Actually, I enjoy gardening. I've got a 1.5-year-old in the background there. She's been really good and hasn't screamed or anything. You want to come say hi, Claire? She keeps
Hello,
us, my
Claire.
wife and I, busy as well. Here, you want to say hi too? This is my wife, Julie, and our baby
Hi,
Claire,
Julie.
our 15-year-old daughter, who is not as busy.
Wow.
This is Claire. She's
Hello,
1.5.
Claire.
She's very busy. She hasn't started talking yet. Oh, she wants to go, I think. And keeps us busy, keeps us healthy, both from a uh, running around the house standpoint and also just a mental health standpoint. She's terrific. So.
Oh, wow. No, thank you, Troy, for coming on the show. You've been great. You've been excellent. You provided great information. Thank you for coming on the show.
Well, thanks so much for having me. I appreciate it. I'm glad we got an opportunity to chat, and we chatted before this. I'm glad everything's going well for you and your practice. Also, best of luck to you moving forward as also your viewers. Thank you so much again for having me on. Appreciate it.
Well, thank you again. And if people want to reach out to you, can they reach you?
It's they can call that number 888-200-9824 or lonelawyer.law. It's lonelawyer.law, LAW at the end. Gives us all contact information, sort of sense for what we do and how we do it. Feel free to stop by and happy to chat. Happy to give advice, even if we can't help. We actually take on less than 10% of the calls that we get. I'm always happy to give direction and help to people who need it.
That's it on Legal Angle with Emmanuel De La Alawale. Thank you for joining us. Until next time, stay safe.